Sorry,
In the real world,
yes,
there is no benefit unless she runs out the clock before the government gets a warrant, I think. Is that right?
I think that is the situation that we are mostly concerned about.
Okay.
Yes.
And if that's the situation you're concerned about, it seems to me that it's a very unlikely scenario to arise, except for, as Mr. Unikowski says, if the violation occurs at the very end of the supervised release period, it might escape detection. And similarly, though that's true with anything a supervised release individual might do, any crime he or she might commit might escape detection at the end of that period.
So respectfully, Justice Gorsuch, I disagree about the likelihood of the 3583I mechanism failing. So I think, as has been discussed, we have the Swick case out of the Fifth Circuit where a defendant was serving a state term of imprisonment and then did not report to her federal probation officer as she was directed. There's the Crane case out of the Ninth Circuit where a supervisee was in a residential treatment program, left early, and that was not reported to the probation officer.
But it's also possible a probation officer will miss other crimes at the very end of a period, too, right?
Absolutely. These were not right at the end of the period, though. I mean, this is, there are several
Well, if the government has a problem getting warrants, maybe the government ought to go to Congress and ask for I to be amended, as it already has once. Thoughts?
Well, Your Honor, so, I know that the government occasionally comes in here and pleads like resource constraints and administrability
That's what this one sounds like to me.
Well, let me just say, with all respect, this process is completely between the probation office and the supervisee. The government does not get involved until the adjudication stage.
Hold on. The probation officer isn't a government employee?
The probation officer is a member of the judicial branch.
I understand that, but you're pleading constraints for the government in whatever form it may be. And
Sure.
I appreciate those constraints. But the government's always been able to go to Congress, and in fact did, to amend I once already. Congress has proven pretty solicitous in this area. And the alternative is for us to create a fugitive tolling doctrine pretty whole cloth. And there appear to be at least two circuit splits. One about what is required to abscond. Is it just not showing up, or is it actually being completely unavailable for supervision? Another circuit split over what it means to be an absconder. Does it start when the status arises? Does it start later? And so we're going to have to come up with a whole common law doctrine here to supplement what I already says. Thoughts about that?
Well, Justice Gorsuch, I disagree on the circuit case law on what constitutes abscondment. I think that the courts of appeals that have adopted our...
I thought the Ninth Circuit said it's merely failing to appear, and the Fourth Circuit says you have to act in a way that precludes the government from supervising.
So I think 20 years ago, the Ninth Circuit had one case that said that it could be any failure to appear or like anything that violated a release condition. Since then, they have clarified in Ignacio Juarez that it is actually a pattern of conduct that prevents supervision, that precludes supervision. And I think that is fully consistent with what the Fifth Circuit said in Swick and the Fourth Circuit said in Thompson.